Good morning to everyone who's joined us for the first online virtual town hall hosted by the National Property Practitioners Council. My name is Vuyiswa Ramakgopa. I'm chairperson of the NPPC. Unfortunately, our program director, who was scheduled to be running the program today, Mr. Brian Sango, was unable to join us this morning as he's been involved in an accident, but he's on the road to recovery, so we've heard. Our thoughts are with you, Brian, and we wish you a speedy and full recovery. So today, unfortunately, you are all stuck with me. I will be filling in as your program director and moderator for the duration of the discussion today. I'd just like to begin by thanking our partners, Cliff Decker Hofmeyr, for assisting us today by providing the virtual venue, and especially to Karushka Naika, Ralph Hopkins, and the entire team for assisting us with the event logistics. To Karusha and all of our Hindu members, we wish you a happy and festive Diwali and wonderful weekend. So before we get into it, by way of background, the NPPC is a voluntary council whose members include all of the major national real estate industry associations. So the council's member organizations collectively represent over 40,000 registered practitioners involved in all aspects of the residential and commercial real estate industry, making us effectively South Africa's largest property sector trade association. Our founding members include SIBIP, Institute of Black Property Practitioners, who I am also representing, SAPOA, IASA, RIBOSA, National Property Forum, the National Association of Managing Agents, the Business Brokers Association, and SIA, the auctioneers. However, membership of the NPPC is open only to organizations, but we are, of course, still open to any other organizations within the real estate industry. So, as I said, it's open to organizations. Membership is open to organizations, not to individuals. However, if you are a member of any of the aforementioned organizations, you are, by extension, a member of the NPPC and you are represented by the NPPC. So a warm welcome to all of our members this morning. The NPPC was also established to provide a single collective voice for the property sector, uniting all agents, business brokers, bond consultants, developers, managing agents, and all individuals falling within the ambit of the Property Practitioners Act, which of course also provides for the regulation of property practitioners. Today, we are joined by some of industry's leading practitioners and experts from various subsectors of the industry, who I will be introducing in full shortly. Just in terms of the discussion today, as many of you will know, the current draft property practitioners regulations are currently still open for public comment. Some of you would have attended the public comment sessions and made your inputs directly. The objective of today's discussion is also to hear from you. So we'd like the session to be as interactive as possible. So please pose your questions or comments on the Q&A button on your screen. On my screen, it's somewhere on the kind of bottom right. It's a little, what do you call that thing? Anyway, it's a little speech box with a question in it, and I think it should look the same on your side. So please do pose your questions and inputs into that Q&A box. For those of you, and there are a few who have already, and I thank you. So for those of you who've already sent in questions, we will try to get the panelists to respond to some of the questions during the course of today's sessions. They have been sent the questions, so they may incorporate them into their opening remarks. However, if there are aspects or things that have not been covered by the end of the session, today is not the final and only time to make your inputs. You can still get in touch with us later. In terms of the program today, we're scheduled to be online for about an hour and a half. We're aiming to conclude by 11:30. So I kindly ask all the speakers to please adhere to your specified time limits. And I know you've got a lot to say, but anything we don't cover today, we will also make it possible for people to send you email questions that you can answer in writing after today. So with that said, I think we are ready to jump into it. Our first speaker for the day, who will be just giving us our opening presentation, is Mr. Clem Daniel. Mr. Clem Daniel is a director at Cliff Decker Hofmeyr. He's director of corporate and commercial at Cliff Decker Hofmeyr, and he's quite the expert when it comes to the regulations. So he'll be just giving us his take on the current regulations and a bit of a legal explainer on the documents that we have in front of us. Over to you, Clem. We can't hear you yet. If you could just unmute yourself, Clem.
There we go. Thank you, Vanessa. Much appreciated. There we go. Friday the 13th, 2020. Thank you for the introduction. You set a high bar for me by referring to me as the expert. I'm not sure that that's true, but certainly I've been involved with the commentary on the Act since the first draft of the Act was published, and I've been closely involved with the process around the regulations as well. So I've got a bit of background to it. That doesn't mean I know everything or that I remember everything in the Act or in the regulations, so it may not be that hard to trip me up. But the focus today is really on the draft regulations, which were published actually in March. So they've been around been available for quite a while. And the window for commentary has been extended to the 20th of November. It's a fairly lengthy document, and we obviously can't go through it all in the next 20 minutes. So what I'm going to do is just indicate to you what the structure of the document is, and then call out a couple of points which I think are going to be of interest. And there's quite a few, and we'll see how many I can get through in the next 20 minutes. If you look at the draft regulations, you'll see there's a table of contents in the beginning, and it's broken into a couple of chapters. There are essentially 8 chapters dealing with firstly exemption, secondly transformation, thirdly compliance, enforcement and dispute resolution, fourthly fees and the Fidelity Fund, fifth the Fidelity Fund certificates, 6 trust accounts and details of auditors, 7 training, conduct and consumer protection measures, and then 8 administrative and other matters. And at the back of chapter 8, there are actually a couple of schedules as well, which quite a couple of interesting things, in which quite a few interesting things surface. So that said, what I'm going to do is just go through it and call out for you a couple of points of interest. You'll see that the Act now has a whole exemption process in it, and what it allows for the authority to exempt people from any provision of the Act essentially, and the regulations set out the forms and the process by which the exemption is going to operate. One of the interesting things is that there is a mechanism now for people to be exempted from operating trust accounts, which I'm aware has been a source and issue for property practitioners over the years, because not everybody needs a trust account, not everybody operates a trust account. So it's been a bit of a concern. And you will see if you look at the regulations that really what you need to do is you need to submit an affidavit saying that I don't take trust monies, or I will no longer be taking trust monies. There's a process, you close out your trust account, and if you want to take trust money again at a point in the future, you then have to let the regulator know. I'm also aware of the fact that there is a proposal, and because I'm involved with regulations very often, I'm aware of further proposed amendments that some of the industry organizations may be making. I'm aware that there is a proposal that, or to be made, that natural persons, in other words, ordinary people who are not running a business as such, but are simply estate agents, will not be required to operate trust accounts at all, that there'll be a species of blanket exemption for them. So we'll see what happens with that. Transformation Chapter 2 is obviously going to be of very great interest to a lot of people. It really allows for the authority, or the Estate Agency Affairs Board is now, there is the possibility of a grant out of the Fidelity Fund to create the Transformation Fund. We don't yet know what the numbers will be. We do know that in the regulations there is a limitation which says that the Fidelity Fund itself may not be reduced below, I think the number is 500 million. So there's a floor to protect the Fidelity Fund, but the rest of the money is available for various grants and purposes. And if you look at the transformation aspect, you'll see that it has a number of elements in it, including the development of SMMEs, which are owned and operated by historically disadvantaged people, the training of property practitioners, and then also to assist people who have not fallen strictly within the existing or do not fall strictly within the Act and the regulations to regularize their affairs. In other words, the idea seems to be less about penalization than assisting people, getting them on board and getting them regularized. I am aware of the fact that there's been quite a level of submission on this Chapter 2, and I'm expecting the revised regulations to show quite a number of changes, enhancing the principles that are already there and fleshing out on them. I'm just keeping an eye on time here. Then the next point that I think I would like to touch on briefly is just fees and the Fidelity Fund. The fee structure seems to have been simplified. What you have now is you have 2,340 Rand for 3 years. Remember that under the Act, under the existing Estate Agency Affairs Act of 1976, you have to apply for a new Fidelity Fund every year. And you have to apply for it by the end of October, and then it's supposed to have been issued by the end of December. Under the new legislation, your Fidelity Fund certificate will be good for 3 years. So the regulations provide, and if you look at Regulation 17, and it actually says as of the calendar year 2020, because it seems to be the case that the regulations were meant, and the Act was meant to come into force this year, but of course COVID turned everything on its head. So it's 2,340 Rand for 3 years, or there's an option, and the wording I'm sure will be adjusted to pay 780 Rand per year in order to ease cash flow for people. And then candidate property practitioners, 380 Rand. And what is quite interesting is this is then connected to the increases in CPI. So it seems that this will be a fairly stable number going forward, that, we're not going to have regular changes in that. The Fidelity Fund, just to point out to you that maximum claims from Fidelity Funds, from the Fidelity Fund, is limited to 2 million Rand in respect of each cause of action. So that is something perhaps for the public to be aware of, that if one is dealing with very high value sums of money, that the full sum may not be covered by the Fidelity Fund. It's something to be aware of. In relation to Fidelity Fund certificates, you'll see there's a form of Fidelity Fund certificate, which is prescribed now, and I will touch upon it again later, but essentially you're only going to need one Fidelity Fund certificate for all the capacities in which you act as a natural person. Currently, I believe the practice of the EAAB is that people often require multiple Fidelity Fund certificates. For example, a principal who has an interest in a number of different property estate agencies often has to have multiple Fidelity Fund certificates. The intention appears to be to change that and to simplify it. I'm also aware that there will be a proposal that the Fidelity Fund certificates may reflect the industry in which the property practitioner is operating, so that it'll be residential real estate or, whatever the situation is. There was a question that came up, and let me just address it quickly now. There were two queries that came through to the NPPC from people that said the declaration on the form of Fidelity Fund certificate only refers to somebody who resides, who is a South African citizen. It doesn't specifically provide for people who are residents, whereas the Act does provide for residents. That's clearly an error in the regulations, and I will in fact raise that as well, and we can ask for that to be corrected in the revised regulation. But if you are a resident, you shouldn't, if you're not a South African citizen but you are a resident, you will be entitled to operate as a property practitioner, assuming there's nothing else that prevents you from doing so. I'm also aware of the fact that there may be a proposal that there's a separate form of Fidelity Fund certificate for businesses as opposed to natural people, but I'm not quite sure yet exactly how that's going to manifest. People there was a question about is the code of conduct going to change, and the answer is yes. The regulations have a whole new section dealing with standards of training and the code of conduct and so forth. I'm aware that there's been a lot of commentary on the training section and the standard of qualification. I'm expecting that will change quite a lot in the next version of the regulations. You will then see that there is a code of conduct. If you look at Regulation 34, and you'll see it's titled Residential Property Practitioners. There's a set of general duties on property practitioners, none of which should come as any sort of a surprise to people, and some of it follows what is already in the Act in terms of the sanctionable conduct. You know, you may not act for two people in conflict and so forth. But there's a whole section on residential property practitioners. There's a duty to disclose and so forth, and not to make misrepresentations. And there's also a series of duties in respect of offers and contracts. It's all quite detailed, and I think it's beyond the scope of a high-level discussion such as this. Okay, there is then a section in the regulations entitled Undesirable Business Practices. And the Act in Section 63(1) permits the Minister to, by notice, declare certain practices to be undesirable. And I think some of these may make certain people a little bit uncomfortable, but if you look at the first part of it, and the numbering in the regulations at the moment isn't great. Something seems to have gone wrong with the numbering. But if you look at the first part under undesirable business practices, what it appears to be is that they are trying to preclude relationships between attorneys and estate agencies, and in particular, it seems to be targeted at the situation where attorneys actually own estate agencies and use them to drive work back to themselves. I'm aware of the fact that this has been a bone of contention for the broader estate agency industry for some years. And in fact, if you go back and you look at the commentary to the 1976 legislation, before they enacted the legislation, when they were debating it, if you look at that commentary, you will see in that already, it was already evident that there was some tension there in those relationships. So that's the first part of it. The second part speaks to the question of an organization that manages a property development. And I'm aware that there have been concerns that estate agents and property developments or homeowners associations or managing organizations enter into exclusionary relationships where only that estate agent or group of estate agents are able to sell the properties in that particular development. This has been perceived as being exclusionary and also, I think, to a large extent, anti-transformative. And so what they've done is they've inserted some language which is quite broad and has a number of subcomponents to it, but effectively trying to shut out or trying to prevent these exclusionary relationships which prevent estate agents generally from being able to access those properties and be able to sell them. And no doubt there's going to be a great deal of debate around exactly what the language there means and how it should be interpreted. I think I have a few more minutes. Just to draw to your attention that there's now going to be certain wording which you need to include on your correspondence and in letterheads and agreements. If you look at Regulation 37, it's very simple. It refers to the fact that you hold a Fidelity Fund certificate. The Act also introduces the idea of major and minor contraventions and fines. The idea of a minor contravention is it's something that you effectively wrapped over the knuckles for. You pay your fine and it goes into history. It's never held against you again. It's not a consideration when you apply for a Fidelity Fund certificate or anything like that. And in a sense, I suppose it goes hand in hand with this philosophy I mentioned earlier around trying to regularize the industry as opposed to acting, in a punitive manner. And there's a whole series of fines and so forth. We did receive some commentary that some of the fines seemed quite low. It's a matter of perspective. What is low for one person is very high for another. And if you look at our criminal law, for example, sometimes the fines seem very high and sometimes they seem very low. And I'm not sure if there's necessarily a perfect rule of thumb. Regulation 40, specification of other services. Just to say to you that there's, I think I've got about 5 minutes. Is that right for you, sir? Yeah, I think I've got about 5 minutes. If you look at Regulation 40, what they're trying to preclude is a situation where property developers effectively act as estate agents themselves without actually being estate agents. So what they're saying is, if you're a property developer and you're marketing and selling units in your property, you must either be an estate agent or you must use the services of an estate agent or a property practitioner, as it now will be. Document retention, the 5-year term for which you need to keep documents in the Act, it's now going to include electronic communication sent to members of the public. The only exception is in respect of social media communication to the public in general. So, a Facebook post which is available to the public, you won't need to database, but everything else is going to have to be database. The administration of exemption applications is quite interesting. There's a whole section dealing with that, as is under Administrative Matters Schedule 1. Effectively, it imposes upon the authority of the EAAB an obligation to consider an exemption application against the provisions in the Act and to grant an exemption application if it can be shown on the balance of probabilities that it will be in the interests of consumers, that there's good and sufficient cause for it, and it doesn't contravene certain of the provisions of the Act. It doesn't contravene the spirit of the Act. There's quite a bit of detail in that, and it's worth looking at closely. There's also a section that seeks to exempt these property portals. They're not really estate agents, they're simply conduits. But what will interest people is there is also a specific provision dealing with the concern around BEE certificates and tax certificates for natural persons. It seems to be, when you read that people are entitled to apply for an exemption when they submit their application for Fidelity Fund certificate to be exempted from holding a tax certificate or a BEE certificate. It's a natural person. BEE certificates obviously don't apply to natural people normally. I'm aware of the fact that there's also a proposal that it should be an automatic exemption. So I think there's been a lot of concern about those requirements, but it looks like what the regulator is trying to do is drive that more towards the business operations than the individual natural people. There are also, in Schedule 2, there are administrative matters relating, it's entitled Administrative Matters Relating to Registrations and Fidelity Fund Certificates. And what this is trying to do is ease the burden on people. You will see in the first part, it's numbered small s at the moment. There appears the statement that you only need a single Fidelity Fund certificate as a natural person, even if you act in different capacities. And what is quite interesting is there's a new provision which says that it says that the Fidelity Fund certificate will not state the capacity in which you hold it. But there's a new provision which says that previous non-compliance issues are not ordinarily a reason for not issuing a Fidelity Fund certificate. There are some qualifications to that, but the intention there is to try and deal with the situation where somebody, many years ago, for example, didn't have an audit certificate or something, and now they can't get a Fidelity Fund certificate. There are also provisions dealing with how a Fidelity Fund certificate is issued. Once it's available on the web portal, you're deemed to be in possession of it. And then there are also provisions dealing with the situation of how you get this to the conveyancer. And saying simply, if you download it in the electronic form and you transmit it unaltered, it's deemed to be an original document. There's then a list of general administrative matters. I think one of which, the most important of which, is that there's a clear statement that if you have a claim against the Fidelity Fund for theft of money, a claim against an estate agent, you don't have to take legal steps against the estate agent first. All you need to do is report the theft to the police, and then you can claim from the Fidelity Fund certificate. I'm aware that in the past the EAAB has required people to first follow their own processes and exhaust that. And then just to say to you in closing, because I think I'm now out of time, that I'm aware that there's a proposal to include certain transitional provisions in a Schedule 5, which will address the question of bridging the gap between the existing Act, the old Act, and the new Act, and the Fidelity Fund certificates. So, for example, if the new Act comes into effect in April next year, your Fidelity Fund certificate issued to you under the 1976 Act will carry you through at least till the end of next year. And there are a couple of other points which we'll address as well. I think that's my introduction, and I'm not sure, are we going back to you now, Vuyiswa, or are we handing over to Zalisa? Okay, back to Vuyiswa. Thank you, everyone.
Thanks, Clem. And I think that was a very informative introduction to the discussion. We've got a lot of comments and questions that have come through on the Q&A chat panel. What we'll do though is just pull some of those questions out and give you an opportunity to respond to them during the Q&A session. What I'd like to do now is just introduce the other panelists, because I think, Clem, what you've really done well is to just give us an overview of what of the salient points of the draft regulations, and thank you for that. Now is a really good opportunity to get some input from industry practitioners and just get a sense of what are some of the key areas that industry is looking at and would like to see coming out of the draft regulations. And I think no better place to start than with Mamxoli Swatini. And I'm just going to quickly introduce all the panelists, and then Sisxolisa, you will then jump in afterwards. So just to begin, our panelists for today, Sisxolisa Swatini, who is the CEO of Xolisa Swatini Properties, and then she will be followed by Mr. Mashilo Picheng, who is the Managing Director of Tsebo Real Asset Management and also the Chairperson of the Policy and Advocacy Committee of the Institute of Black Property Practitioners. And he has a number of other illustrious titles, also very involved with the Property Sector Charter Council and a board member there, so very informed on the transformation issues. And then, of course, Ms. Sonia Pranger Grantham, who is a director from the National Association of Managing Agents, and of course a managing agent in her own right. But just to kick us off, Sisxolisa, maybe you could just give us your inputs from a residential perspective. You know, what are your views of the new regulations? What are you hoping to see, or perhaps what are some of the areas of concern that you have that you would like to see addressed through the new regulations?
Good morning, everyone, and thank you, Vuyiswa, for inviting me to be part of this panel. And thank you for an elaborate explanation of the regulation, which is very promising one, and all the lenient, all other aspects have been addressed and they are friendly. But my more concern in real estate is transformation. To me, all the regulatory law abiding, it's the structure, it's the bone structure, it's the frame of the industry and the maintenance of the industry in such a way that we are going through the straight line, which I welcome, for example, the trust account for people who are not renters and all other things which I'm not going to mention here, because my focus in real estate, which was my experience when I got into the industry, is transformation. I am not sure if this regulation is really answering the transformation. How is it going to happen? For it to be able to do that, I think it needs to understand what it means by transformation, who needs to be transformed, what is lacking in this transformation, and what's missing, because what makes a successful estate agent? That's what we want, because you can have all the laws, but if people are not productive, they're historically disadvantaged that want to bring into the industry is not addressed in the regulatory body in terms of making them enjoy the flesh of the bones, because all the regulatory is the framework, is the bones. So we want the flesh. So I don't see it being addressed properly. And the only way it can be seen to be addressed properly is to ask questions like, what makes a successful estate agent? How to turn someone to be a successful agent? How to attract the historically disadvantaged people and keep them in the industry? What makes them not to last in the industry? What is missing? What do they need? What keeps one estate agency like Xoliswa Properties, for example, who's been in the industry now, say about 20 years, close to 20 years, what has made our company to stay and it's missing for other people to be retained? Because there are many historically disadvantaged that come into the industry and leave the industry. I don't think much has been looked into the fact that why are they leaving the industry? What is missing in them? And I haven't seen much in the document that's talking about regulating the developers. Yes, there is a piece that talks about a developer needs to assign an estate agent to a practitioner to sell their development. But it's not coming clear how to make sure that you have given the development to a broader number of estate agents that are also historically coming from a historically disadvantaged background that can participate in these developments. Because even now, the developers are using the services of estate agents to sell their development, but in that they're so discriminatory. They're not using the historically disadvantaged estate agents or practitioners to participate in those developments. They're using a few of those. Those are critical questions that I think needs to be addressed. I have seen there is a fund allocated about 8% or 7% for awareness and education. I welcome that, but that needs to be structured. If you see the historically disadvantaged group of estate agency, one of the reasons they're not succeeding in the market is because they don't have stock. I'll make an analogy and say, for example, if you are a swimmer, this group was taught how to swim and they know how to swim. To me, that will represent the historically advantaged group. They were taught how to swim, how to navigate in the industry. They grew up in backgrounds where property was known to be money and an investment. There is a historically disadvantage who grew up into the environment where property was a home just to live in and leave it to your children, and it's not an investment. They don't attach money to that. So you can't take these two groups. Take this as a river. You cannot take these two groups and take it to the river, in that river of real estate, and say, go and swim. Naturally, the historically disadvantaged one will not be able to swim. If they can, they will swim a small distance and then they will drown. But those that have been playing into the industry, they know all these regulations, and most of them, they play into their field. The fee that is paid, they've got that. They've made a lot of money from there. Not only that, if you see how they managed to get their stock, we must look at what has the previous government assisted them to grow into the industry and accumulate the residential relationships in properties, how these suburbs were developed from what, where was the land coming from, and those relationships have been formed 30, 20 years ago, where were other groups, they were not there 20 years ago. We need to invite the government, the private sector into the space and see how they unapologetically make sure that the previously disadvantaged are given enough, because all we need is stock and form those relationships. Development of the new suburbs and development of the new township. We should shy away for always being diverted to human settlement, RDP homes. Why are we not diverted to affluent suburbs? Why can't they say we're developing a village, we're developing a suburb, we're developing this area? So we've invited these companies, we've invited Xoli Eswatini Properties, Kokoma Properties, Thamsanqa Property, all the names, not only the yellow, the green, the blue, and whatever. We must start creating the majority of the indigenous clicked real estate that the young children can look up to and say, look, I want to be like Xoli Eswatini, I want to be like Kokola Tini, I don't want to be like, I'm not going to name other blue. I don't want to be blue. I don't want to be red. I don't want to be green. I feel proud. That's my role model, because the regulation is putting a ruler, putting everyone into the same rope. It can't be like that. There has to be a preferential and a way to make sure that transformation kicks in. I've started in the industry. I know how difficult it is. I know how difficult it was, and real estate is the vehicle that can enhance and encourage people to alleviate poverty if they are trained. It's not for everyone. I want to agree. Real estate is not for everyone. It needs a certain personality. It needs teachable people. It needs hardworking people. But are those people given that opportunity? And another thing I want to point out, when we start about training and we're starting on the upper level, I've gave a vision and a picture of these two groups. The previously, I think that education should start from school, in those disadvantaged schools, so that people can understand the value of a property. They can know that as a vocational guidance. I've never received a vocational guidance. I think if in my years I was introduced in early ages that property is money. When you see a building, you see money. I'm sure if many has happened in our schools when we were coming up from schools, our grandmothers who brought us, they had no knowledge of that. So I think if that has come from that direction, today we wouldn't be seeing people who are banning buildings, because they will see the value of a building. That's my introduction to you, Vuyiswa.
Thanks, Xolisa. Exactly what I always know about you. You always speak with such passion and conviction. I heard you when you were saying you want people to say, I want to be like Xoli Eswatini. I want to be like Xoli Eswatini. So our next speaker we're going to introduce is Mashilo, Mr. Mashilo Picheng. And I think it's a good segue, because Xolisa has touched a lot on and spoken a bit about the transformation question, and of course being in the space herself. But I think, you know, obviously your work with the Charter Council, your work with SIBIB, and in the industry as a whole, especially your view coming from the commercial industry, understanding also the residential industry. What are your views on the current proposals that are on the table around transformation? Are they going to deliver the intended outcome?
Thank you very much, and welcome to the rest of the colleagues on the line. I think one of the things that, let's start with demystifying some of the myths about transformation, because I think one of the fortunes that I've had was to go around the country training estate agents or presenting to estate agents on the legislation in terms of the BEE legislation and also on transformation. And there are two basic questions that are always asked. One of them is to say, are you asking us to take a portion of our business to give it away to somebody else just purely because they are black? The second question was, Are you asking us to train people that and contribute money to people that are going tomorrow take away our business or compete with us? And the reason why I need to get that off the table, it's actually transformation is not about that. And if your view of transformation is about somebody rocking up into your business taking 20% of your business or 50%, get that out of your head, because that's not transformation. What transformation is how do we restructure the industry in such a way that we can all share the cake? What do I mean by sharing the cake? If you go back to what Sisxoliso was referring to, if you go to 1994, and let's use 1994 and not be pedantic about time, that Black people were not allowed to kiss, smell, think, dream, anything property. So you wouldn't even, so a career in property, even thinking property was out of your realm. So because of that, you would imagine that come 1994, the stock or the trade and the disadvantage to trade was also on both sides, because you had about 13,000 agents in 1993. All of them were white, 0% Black, and all of them can trade between themselves. They cannot trade beyond their suburbs. So the amount of properties that could exchange hand in the market was very limited to that group and to their suburbs. Come 1994, somebody rocks up and says, you can trade anywhere else you want. You can do anywhere else in the country, whichever way that you want, as long as there's a market. That is why since 2006 until today, this market, 90% has been driven by the Black middle class. And there's no agent that exists now, without a doubt, and I speak without conviction, that can say, I have been in the industry for the past 10, 15 years, and I've not done a transaction, or I've not taken a client that is Black to go and view a property. So this market has been driven like that. So the question we need to ask ourselves essentially is this, and then I'll try to do this thing in 3 minutes. One, how do we make sure that the participation of the Black people, and I won't say historical disadvantage, because I think women are also in general, whether white or Black, they were historical disadvantage. So I prefer to use the direct term, which is Black. How do we make sure that Black people are not only seen as consumers of a product, but they also participate in the value chain? Secondly, how do we make sure that the value chain itself in the sector, it's so transparent that we not only get boxed into what Sisxoliso is talking about, all of us want to be agents, whereas the value chain is beyond just selling and leasing. There are other activities that happens in property that are beyond selling and leasing. And how do we make sure that we understand transparent that we can participate across all of that? And in doing so, the legislation, I think, and the regulation as it comes across, and then I was part of the process to make sure that if for those that remember when this thing started, this was not even a transport, was not even a chapter, it was a one-liner. And we fought very hard. And we need to acknowledge that for it to become a chapter and to become a section on its own, yes, it still needs a lot of work. But that by itself, it's an achievement that there's a recognition. What is left for us is to make sure that that recognition says the things that we wanted to say, and those things come into fruition. The second thing is, and it has to deal with how agents see themselves. And I use the word agents deliberately, because as long as you still see yourself as an agent, not as a practitioner, is you will behave like an agent. That means you will behave as if you're still operating under the State Agencies Act. And we need to move that cohort from behaving like agents to becoming practitioners, because it's a different mindset altogether. And it's a different way in which you must look at the industry. Now, what does that mean? And I'll use the example that Clem was using earlier around the old fights between lawyers and agents about fighting for space and developers. It is easier to recognize that fight as an agent because you're looking at yourself as an agent, whereas you are actually doing exactly the same thing to other professionals, where agents go around cannibalizing valuers, they go around cannibalizing inspectors, and I'm talking home inspectors, because they believe that they can do that themselves, which is something that they don't like attorneys doing to them, but they are doing it to somebody else. So when you look at an industry in that fashion and look at a value chain in that fashion, you recognize that the things that you have a difficulty with are the same things that you are doing to somebody else. And sitting around the table like this, we are able to say, You as an agent or you as a practitioner specializes in a particular practice. If I'm a dentist, I'm not a surgeon. I need to focus on being a dentist. I must not go around trying to be a valuer because I'm afraid the home inspector is going to mess up my transaction, so I'll do it myself. So I'm a practitioner, and part of this legislation is to start developing professionals, property professionals. And if you begin to look at the sector that way, and you move away from looking at yourself as an agent, just merely interested in the next transaction, then you'll see that the industry is much broader than just the next transaction or the next meal, because then we're behaving like politicians. Lastly, the point around why is this legislation, why is this change? There are two fundamental things, or else we don't need this change. The first fundamental reason why we need this change and we need this new legislation is that the type of consumer the Estate Agency Affairs Act was created for no longer exists. And we must accept that. That consumer existed maybe in the 60s and in the 70s. Today, that consumer doesn't exist. So the type of public protection that the Property Practitioners Act is bringing, which is what we are dealing with the regulation, is that it's trying to deal with a new type of consumer, a new type of a public that consumes property services, that consumes property products. And you begin to recognize that, you begin to recognize that the legislation cannot be a lipstick on a pig by just reinventing the Estate Agency Act as something new. And that becomes fundamentally important because then chapters like the transformation chapter, chapters like the ones that Clem were referring to becomes very important, because it means that you need to begin to look at other professions, whether it's attorneys, conveyancers, valuers, whatever. You need to look at them with a different eye. You need to look at developers as part of the value chain. And we need to be able to regulate each other to say, what is my role in the value chain? What are the activities that goes into the value chain and who plays the roles? Me as an agent, I play a role in the value chain, and how do I regulate myself? And I need to be aware, when do I hand over to the next practitioner? The next practitioner might be a conveyancer. How do I hand over to the conveyancer? After the conveyancer, there's SARS. How do I hand over to SARS? That's how a value chain operates. Lastly, it's about access to market. And if you don't address this issue, and then it will sound like a repeat. So, and part of the conversation is that we don't want to end up as what they call a work in progress. I've got this thing about training. Almost every company you go to, they feel that you need to be trained. So you become a perpetual work in progress. And the danger with this legislation, it's reintroducing that sausage machine where people become perpetual work in progress, so they never get there. Why is that? It's because there's three fundamental things it doesn't deal with. One, access to market. Two, is about what is it that we can transform, and that is the legislation. Unfortunately, Sister, it can't deal with the legislation. It's about how do we change attitudes in terms of how we look at property. Before 2006, all of us as Black people, it took us that time from 1994 to 2006 to begin to buy into property. It's going to take us that long time to begin to recognize property as an asset, but it is us practitioners who are responsible to make sure that happens. It is us practitioners who are able to deal with that. And the final thing is about the size of the market. We can keep training people. Is the market sizable enough to absorb the people that we're trying to bring into the sector? Are there other avenues of the market that we have not exploited? Or are we trying to exploit RDPs or township market with the same lens in which we are dealing with the developed market? Let me call it that way. In the bank, we call it the bonded market, because that's not saying my grandmother doesn't need a bond on her property, but she wants to sell her property. If you approach her with that attitude, is with the model that you have known, that you have created for a long time, that's not going to work in that market. So we need to begin to create markets. And in creating markets is then that we're going to be able to understand what is the size of this market. The size of this market is not only what goes through the bank, is not only what goes through dead people, is not only goes through what people are divorced. The market is much bigger than what we can think of that we have not tapped into. And I think this legislation in part tries to deal with that. it is the responsibility of us as practitioners to be able to recognize that it is trying to create a market, and we should refrain from trying to put a lipstick on a pig, because we are still bought into the Estate Agency Act and we want to see it reflected in this particular legislation, which I think it will be a disservice. Thank you, Vuyiso.
Thanks, Mashilo. Always very insightful, and I think you've made a couple of really important points. You know, are we just reinventing the old legislation, or, as you say, putting lipstick on a pig? How should we be thinking differently about the industry as a whole and all the different players in the industry, about how we are interconnected in the industry, because that is indeed one of the key aspects of the regulation. It's about uniting the industry and bringing everybody under the same umbrella, so that we no longer have, you know, the kind of East Coast, West Coast situations that we've had in the past. Our next speaker, Sonia, and I'm glad to see you on. There've been a number of questions already that have been directed towards managing agents. So Sonia Prain-Jagrantham is a director, as stated, of the National Association of Managing Agents. And you, as an organization, have made a number of inputs to the regulation. I know that a big focus on your side is around education and training, but of course there are a number of other very important considerations that you guys are looking at from the perspective of managing agents. Maybe you could just give us a view about some of the key issues and things you'd like to highlight.
Thank you very much. I have to fill very big shoes that went ahead of me here, so I'm going to try my best. So as managing agents, which word is just a horrific word in my personal opinion, becoming a property practitioner would really, I think, would professionalize this industry. So NAMA submitted a number of comments to the Minister's Office in respect to the current legislation. And I think the main concerns are around the definitions of a managing agent. We need to be very clearly defined in the new legislation, because some agents or some managing agents, as they're currently called, don't sell, they don't rent, they don't take trust funds, they do on behalf of a community scheme as defined per CSOS and per the Sectional Title Schemes Management Act. They do certain functions as legislated in those acts. So we need to be clearly defined. And in order for us to do that, I think the current legislation is perhaps too broad, and there needs to be a certain section in the proposed legislation stating that this is the term of a managing agent, this is the function, this is the duty. Yes, the Fidelity Fund, yes, all of those requirements. And I think the FFCs, for me personally, are important to a certain degree. Trust accounts is very questionable because most of the community schemes these days run their own banking accounts. So body corporates and homeowners associations, they don't utilize trust accounts. So you've touched on some major comments and with regards to this. But one of the big things for us as well is training. And NAMA is in the process of registering as a professional body, and NAMA has been the leader in training managing agents and training community scheme members, trustees, directors with regards to the legislation, may it be the Companies Act, may it be a Sectional Title Schemes Management Act, or may it be now with the CSOS, which has been very refreshing for us in our industry. And in order to transform this particular industry, I really believe we need to develop professionals who clearly know the difference between a selling agent, an auctioneer, a managing agent, for the lack of a terrible term. We need to be clearly defined. And I think that the training and the upliftment in this industry, it's such a massive industry and there's so much opportunity and scope here. the developers are just building and building and building, and there is just so much scope here for new companies to come in, and for this industry to be transformed, and for us to have a great representation from the black community, because I do look at it, and this is my personal opinion, and I think, where are they? I have many clients that are from very diverse parts of this country, and it's so lovely to interact with those people. But I want to see them in my industry. I want to see them at the NAMA training or at the property practitioners launch. I want to see these people. So I think, for me, in a nutshell, it's just managing agents need to be defined, and I think a little bit more in the legislation needs to be set out about managing agents, because I will state, in my opinion, there are some agencies out there that are rogue, and they kind of do as they please, and they pop up and they disappear, and they pop up and they disappear. And that is, for me, a very dangerous situation for the entire industry as a whole, because we all do fall into different. I love your explanation of the fact that we should all kind of be I can't remember who mentioned it, but at the end of the day, we need to be a circle. So we all are going to join into the circle, because we all have different aspects that we're dealing with in the industry. So I think we need to be defined in terms of our different aspects. Thank you.
Thanks, Sonia. That was sweet and short and concise, but there's a lot of questions, as I said, that have come through. So I think that's actually great. It gives us some good time to actually jump right into some of the questions. I'm going to start with you, Clem. There's a few questions that came through whilst you were making your presentation. And I think I don't know, everyone can hear me? Okay, sorry, thanks. So what I'm going to do, Clem, is we're going to just do what I call like a rapid fire Q&A. So short and sweet, simple yes or no if you can. And I'm going to try and get through a good 5 or 6 questions in a rapid fire format. So hopefully we can make it work. So first question, Clem, how do the REITs comply? Are the REITs even covered by this regulation?
Unmute, Clem. Sorry, unmute.
Unmute yourself, Clem.
There we go. Always good to get the reminder. Thanks, Ray. I've been answering some of the questions in the chat box while the other panelists have been busy talking, so I've been a little bit naughty there. The answer is I don't know how REITs comply with ISWA, and I indicated that it's an issue that actually will need proper analysis and thought. And a number of the questions I can answer fairly easily, and some of them are matters of interpretation and close analysis. But let's keep going.
Okay. I'm glad to hear you have already been answering some of the questions. So what I'll do is I'll actually just read some of them to you. Perhaps you've already touched on them, but maybe just for everybody's benefit. So when will the PPA regulations become effective? Do you have an indication of date? The other question, if you have a trust account, must you have an audit? And a third question, what is the position regarding FFCs issued subject to BEE compliance? I think what the question there is trying to ask is, what is the BEE compliance requirement, and is the FFC contingent on that? And then another question that came through said, are developers and sellers of life rights in terms of the housing development schemes for retired persons seen as property practitioners, and must they comply with this act? So that word property practitioners, hey, we're all going to have to really learn to wrap our tongues around that.
Yeah, and trust me, I get caught regularly on that one. I often talk about estate agents, but we need to remember that the new act is wider in terms of its ambit than the existing act. Let me just try and knock them off quickly as best I can, not necessarily in the sequence which you had them. When will the new act and regulations become a force and effect? We thought originally that it was going to be this year still, and I think that is what the minister intended. But I think COVID caught everybody. That caused the delay, and I think, they still need to go through the commentary process on the regulations and so forth. Current indications are, I believe, probably around the end of March next year. No certainty, but that's what the current indications are. The question around developers and sellers of life rights, for retired persons and so forth, I think technically they may well fall within the definition of property practitioners, but it's something that you really need to, it's one of those that you need to analyze and really think through properly. It's not the sort of thing you can give a proper answer on, and a quick answer on a webinar like this. If you have a trust account, must you have an audit? In principle, yes, the audit requirements still remain. It's for that reason that if people don't want to have that audit, that you really need to go by the exemption process. Don't run a trust account. It's as simple as that. There are other organisations that will run trust accounts for you, and that is in fact specifically addressed in the regulations. These organisations that actually operate a trust account for the benefit of an estate agent, and that takes away the burden of the audit as well. Vuyiswa, what was the next question? What is the position with an FFC issued subject to BEE compliance certificate?
Yeah.
I don't know, quite frankly, because the act says that you have to have your BEE certificate before you can get your Fidelity Fund certificate. So I'm not sure, and this is now obviously subject to the exemption for natural persons, because natural persons don't have BEE certificates. So we're talking about organizations. So I'm not sure you can get your Fidelity Fund certificate without your BEE certificate. There's going to be a debate about that. But the answer is if the regulator sees fit to issue a Fidelity Fund certificate anyway, subject to such a qualification, then obviously you will have to have your BEE or empowerment certificate within the time frame dictated by the regulator. And it may be that that the regulator sees that as a practical matter, people won't always have a current BEE certificate in certain circumstances. But I think that I'm hoping that will be the exception, not the rule. What else? I think I've answered the immediate questions.
Yeah, no, perfect. Thanks for that, Clem. There's a number of questions to get through, so I'm going to just go back to also some of the other speakers. So this one I'm actually going to sneak in. You mentioned, I know from my dealings with you that you're obviously very passionate about education, and in your own personal capacity, you run a training institution, and you have been extensively involved in training in your own right. So what are your observations? You spoke quite passionately about what is needed to be an estate agent, what is needed to be, or in this case, a practitioner, property practitioner. What do you think are some of the gaps, perhaps, in the current educational offering? Or where do you think we need to be making, what direction do you think the education needs to be going in? And do you think, if at all, that the current regulations addresses that in any way? That's sort of part one to the question. The other part of the question I want to say, and it follows on from that, is around the interns in the industry. We know that there's quite a high number of interns coming through the system, and many incoming or newcomer agents get stuck at that intern status for years. If I remember the statistic, we're sitting at around 25,000 interns currently in the system. What do you think is the reason for that? And what would you propose if you had an opportunity to wave a magic wand to see that number getting lower, and to how do we progress people sooner from that intern status to where you are today as a principal and business owner?
Hi, Vuyiswa, thank you. Taking the education of the direction that the education should take, I think the education should take a direction of training soft skills. What is required in the industry to perform real estate? It needs to train agents in terms of negotiations, in terms of confidence building, in terms of prospecting, in terms of prospecting, negotiating, develop the attitude and develop motivation to their learners. Because without those things, few things, your negotiation skills, your prospecting skills, your inter and intrapersonal relationship development, chances of anyone succeeding in the real estate are very slim. Real estate is people's persons. You have to, because the current people have, the white people have developed relationships years back, as Mashilo had said, before we came into the industry, and they are recycling all those sales. So now we need our people to come in, and we need to train them to be out there independent and understand that they are in business and develop their entrepreneurial skills and be able to be on their own. That's the line that I would like education to take. Because currently the education, I am running a training academy, the education is taking a form of more intense legislation. Before this education, before we came into the market, there was not this education. It was never there, but agents have made it then perfectly, because they were trained how to find properties, how to negotiate properties, and the education is good. As I say, it's a bone. We need to get to a flesh of it. So that's what I'd like the education to take. I remember I took my daughter somewhere to be trained, and she came back and said, "Mom, your training is more powerful than where I was." You see, because I take passion in training people to be independent. And then coming to intense dropping out. Which I think that what I've just outlined in line of education, it's what disadvantages the new interns coming into the industry. What makes a successful estate agent is to get more stock. And we have no, you can say you can go and get stock, but the competition is so tight. If I had a mage wide, I would look, what did the previous government do to promote and make sure that property practitioners of the time were successful? Look at developments, look at land, how those developers got land. They wrote proposal, they acquired farms, they subdivided them at a minimum cost, and those suburbs were handed over to estate agencies to sell. If you look the history back of how that has happened, you realize that we need to talk to the current government to use the same system, similar system. I mean, we don't have to be apologetic about that. Developers have to, they need to be regulated and make sure they empower, they give opportunities to Black estate agents so that they can have access to stock. Because that's what keeps an estate agent in the market, is an access to stock and be able to get that stock without discriminated. You cannot get these big developers and they give to one agency to sell that property and to one firm of attorney to register that property. That attorney has been there 40, 50 years ago. That agency has been there 40, 50 years ago, and if you look, you get into it, you realize that they have the Black faces, and check the functioning of those Black faces in those companies. Then they take these as interns, and those interns are not given those opportunities. They are limited to say, you're going to work in the township, you're going to work in this particular area. They're not bringing them to speed into being competition with them, because it's a greedy industry. Unfortunately, real estate agents practitioners want it all to themselves. So they feel, I think the sharing of knowledge, the sharing of skills, the showing the know-how to other people, to me, it's very important. Currently, the legislation is looking at the law, which is the frame. I want to say it's not only the legislation that puts money in the bank. that makes estate agents successful is the work on the field. That's where training needs to take place. That's what is going to encourage interns to stay in the market, because it doesn't have a basic salary. I can think that's enough for me.
Thank you. Thanks, Xolisa. And I think you've said a mouthful. You know, it's about substance. It's about the quality of training. If I'm hearing you correctly, it's about actually training people to do the job. And I also like the comment that you made about, you know, when many agents such as yourselves were coming into this space, you know, the training requirements, while they may not have been as cumbersome, they were more effective, I suppose, in really getting people to hit the ground running, to start working, to start trading. And ultimately what it boils down to is your actual access to market and your ability to access that stock. So thanks for that. Mashilo, just on that topic, Clem mentioned earlier on, he made reference to the establishment of the Transformation Fund. You've obviously worked very closely with the Property Charter Council. You've been involved in the transformation discussions at all levels. Is this fund going to solve all the problems? Is it the silver wand, the silver bullet that we've been looking for? And if so, you know, where do these funds need to be channeled? If you had an opportunity to administer the funds and to direct the work of the Transformation Fund in a particular direction, where do you think is the most relevant areas where the fund needs to be focusing to drive the most impact in the entire value chain?
So I'm gonna, just before I get to the fund, I think I need to talk to a point around this skills development thing, and I'm gonna disagree a little bit with one part of what Xolisa referred to around the idea of soft skills. So you've got NQF4 and NQF5. The current regime of NQF4 and NQF5 is designed to creating agents, the sales and the leasing people. That's what it's designed for. It's not designed to create opportunities in the property sector or to create opportunities for professionals in the sector. And that's part of, I think, what's lacking. What am I saying in practice? Is that I think, my opinion is that, and having been involved with the CPDs and whatever with estate agents, is that I think NQF4 should be designed, modeled around creating opportunities to grow. So what do I mean by that? There's modules. I mean, you can have property marketing, you can have property appraisals, you can have property law. At an NQF4 level, I need to be given skills such that, technical skills, such that when I go to NQF5, I can make a choice. So I can say, I've been introduced to this different aspect of the property sector, whether it's property finance, then NQF5 is then I can make a choice to say, you know what, I don't like sales. I want to go to financing. That means I'm going to go into the banking sector to deal with property finance in the banking sector. You know what, I like that law. So that means I can go into do what Clem is doing in the legal sector. And that, for me, that's how this training should be done, to create opportunities, as opposed to channeling people like cattle into a particular stream that they must go into. So the design of the current training is still designed around presumption that everybody wants to be an agent. And I think that, for me, it's a little bit problematic, because what we end up doing, we end up creating, that's why you've got a lot of cohorts that wants to be agents, but the market is also shrinking, it can't grow forever. So I just needed to make that point. With regard to the fund, look, the fund is a brilliant idea. I know yourself, you're also involved in agitating for the fund to be created. The challenge that we're going to have with the fund is how it should function. And I'm saying it's a challenge because even ourselves who are agitating for the fund, we still have to figure out quite a number of things. One of those things is that we need to look at what will be the successful model. I think personally the successful model is to fund those new entrants that have a product on the table. It's like operate like a venture capital kind of structure, as opposed to trying to throw mud and you hope it will stick. I think that if the larger proportion says Xolisa Tini has started an entity is functioning, and that entity it's got buds that are coming, then you are able to put a proportion to that fund. The second part of the fund is towards not only just skills development. I mean, the skills development, I hate the sausage machine story, but towards skills development of those people that are en route to become principals. I think those are the two baskets in which the fund should be used for, to support entrepreneurs that are in the industry, and for them to be able to access the market, you use the fund to do that, to sponsor them, and for the principalization of those people that are, because we don't want people to be stuck at the bottom. I'm quite sure that the system on itself can take care of training. We don't need the fund to be taking care of the basic training. That should be absorbed by the system, whether via the operators themselves and whatever. The fund must focus on at least a little bit above that. Deal with the training to make people principals, and deal with the training to make sure that those that are already principal can be able to access the market.
Thanks. Yeah, and I think, I mean, you've obviously touched on a number of key elements, which is around, you know, the need to focus on enterprise development, actually developing entrepreneurs and business people, or what we call principalization, I suppose, in the regulations, and that should be a core focus of the fund, in your view. Sonia, I'm going to jump over to you quickly. There's a question that's come through specifically with regards to the inputs that NAMA has made. So one of the questions says, please, can you advise what submissions NAMA has made or will make in respect of the educational requirements? And I think it's a good segue also from the chat we're having now. So they say, do you view the current NQF4 and 5 as relevant? And is there a proposal to develop and accredit industry-specific regulation? The current regulation will also be irrelevant to other newly included property practitioners, i.e. timeshare sales agents who are effectively only selling contractual rights. So what is NAMA's take on the current educational requirements?
In my opinion, and from what I've seen that was submitted to the Minister's office, we would obviously like to get a training. There is currently talk about a specific training course, if I could call it that, for the lack of a better word, that will be held, and it will be run through the University of Pretoria, and obviously people that wish to go into the industry would go through that particular process. But I just want to go 2 steps back. Something that you've said is that I think the training needs to be, in order to clearly define each section of what a property practitioner can do. I can be a managing agent, I can be a sales agent, I can be a auctioneer. I think the definitions are the first thing, and then from there we need to allocate the training that's specific to each sector that the person who wishes to come into the industry wants to choose. I wish to become a property managing agent practitioner. So I wish to go through what NAMA's proposal is, and what NAMA's busy developing is a specific course, or and I think that will be only, well, not only, but it will relate to understanding sectional title, community schemes, CSOS, which is vastly different from what an auctioneer or a sales agent would need. So I think I'm echoing a little bit of what somebody else said earlier, in that we need to define each section, and then from there establish what training each section and grounds are required. Because NQF4 and NQF5, which we had to do, there was only small snippets of that were actually beneficial for me. I don't do sales, I don't do rentals, but that were beneficial for me as a managing agent in that course. So yes, NAMA is about training and establishing, and there is something I don't think I'm able to. I think it will be publicised to this forum, obviously, but I would just need to discuss that with the board of directors as a whole, because I think they're busy finalising something that they wish to present. Sorry.
Thanks, Sonia. Okay, perfect. So I think maybe just one more for you, Clem, and I don't know if this is within your scope, but maybe this is more a speculation question from your side. In your opinion, is there a view to review and revise the current code of conduct to make it more enforceable? I think that question, that question came much earlier on. I'm not sure if you had an opportunity to respond to it, but from your assessments, is there a view? Is there a move towards reviewing and revising the current code of conduct, and is there a way to make it more enforceable? Are there mechanisms in place that you've seen provided for in the current regulations?
So I think it is the current code of conduct, if you look at it, seems to, well, the new code of conduct seems to have used the current code of conduct as a starting place, but it's been rewritten quite extensively, and so we do have an entire new code of conduct. Whether it's more or less enforceable depends upon your view of the provisions in the Act. There are a lot of provisions in the Act relating to enforcement, and then you'll see the regulations deal with mediation and adjudication and so forth where there are complaints. I think it is the intention that they will be more enforceable than in the past, but I don't know what the practicalities are going to be from the regulator's perspective, and to what extent, they're going to be proactive in enforcing this. That I think is really the issue. It's a practical issue rather than a function of what does the new Act and regulations say. I understand that there have been a lot of issues in the past with non-enforcement, a lot of concerns, let me put it that way, raised about non-enforcement. So I think it's going to be more of a practical issue than a legal framework issue.
I think, so just as a question to Clem on that, I mean, if you remember, one of the inputs that we have made with regard to this issue of code of conduct, if you remember the earlier days of the legislation of this particular, when it was still a bill, was that it tried to do a creep into professions that are governed somewhere else, like lawyers or conveyancers are governed under a different profession. Whether, will you take people who are in the sector, but there are accountants that are CAs that are governed somewhere else by a different professional code of conduct, whether it's valuers who are also in this particular sector or architects who are. So one of the questions that, and the regulations that didn't answer that is, how do you deal with those? And then what the suggestion that CYBIP had made at the time was avoid a double jeopardy, where if a professional is governed somewhere else by a different code of conduct that is governed, managing agents are the same, they've got a C-source, then the legislation should make reference to, or the regulations should just refer that conduct to that particular applicable legislation or applicable code of conduct, because it's properly governed somewhere else, as opposed to recreating another model where if I rock up as a practitioner and I happen to be in another profession, I get governed by two conflicting codes of conduct.
Clem, I don't know if you want to.
Yeah, I'm just thinking. So, Mashila, thanks for that. Look, I mean, my starting place is that my perspective is that it's undesirable for somebody in a professional space to be regulated by more than one regulator. It creates numerous problems, not least of which is the type of problem which you're now mentioning. And I do know that when the bill was first published, there were a lot of concerns about this dual regulation issue, and in some industries, we in fact we made representations for people in specific industries to try and avoid this dual regulation, and the problems that may come with it. I don't think we have yet fully surfaced where these areas of dual regulation are going to arise, because I don't think we fully understand yet exactly what the application of the Act is going to be practically. You know, you can read the definition academically, but that doesn't necessarily mean you understand it fully. And so I think there will be some issues in the future. The regulations, if you look at them, are drafted primarily at this stage with estate agents in mind. It is conceivable that as other industries come into play, and I'll come back to that in a moment, that the regulations may be amended to deal with other industries, and there may in fact be specific regulations which deal with the very type of concern you raise, which is to say, you know, which code of conduct applies. There is a school of thought to the effect that when the Act and the regulations first become effective, and this is pure speculation on my part, but there is a view that it may only apply to the residential estate industry to start with, and that the other industry sectors will be phased in over time. So we will just have to wait and see how that plays out. I don't know if that fully answers your question, but I think it's the best answer I can give you right now.
Okay, as we kind of near, I can see time is ticking along, and as I said, we are scheduled to close off at 11:30, but I just want to see if we can squeeze in one or two more questions and comments before we close off. Siskoliswa, I'm going to throw one your way, and this is really about the idea about regularization. There's a big move, as you know, to regularize what we term as illegal agents, or agents who are trading illegally. There's a sentiment also coming also specifically from Black agents that, you know, the existence of these so-called illegal agents is actually in itself a setback to some of the, you know, the transformation objectives that we're trying to achieve. And in fact, a lot of these agents cannibalize on, you know, the little bit of whatever business that's available is actually currently also under threat. So what would your views be about, there's a proposal on the table currently to provide for some kind of a blanket amnesty for agents who are trading illegally, to give them an opportunity to come forward, clear their names, clear their status, get in the system, and then of course after that, all of those then who then decide to trade illegally would obviously then face the harshest consequences. What would your views be about some kind of a blanket amnesty for illegal agents? Would you, as someone who's currently trading in the industry, support that type of proposal or not? And if so, why not? Or why would you?
Yeah, I'll support that very much so. I think the fact that now if you are not keeping any monies, you are exempted from an FFC. You're not FFC, sorry, man. You are exempted from the trust account. Issues like those will allow them to come, because probably other people, this requirement of opening a trust account, but the only way we can manage that, I think, would be if you are not doing any rentals in your real estate, you should not open a trust account. And most of these illegal people, agents who are selling properties to ignorant people who do not know what is the role of an estate agent. They think it's just a transactional situation. I get many people coming to my account, to my office, having robbed by an agent who's illegal in my community, but I go and address those matters and refer them to an attorney. But I think the amnesty would be very good. And I'll also assign us as registered estate agents to extend a hand to those people who are acting illegally and see how can we assist them and give them the proper training, and how can you assist them into putting up their small offices legally with a Fidelity Fund certificate, and show them the benefits of belonging to a legal body, which is the EAB. Amnesty, yes. Extend training from our side, yes. Us, as legal agents, we have to extend that training to them. The fact that the legislation now has done away with people who do not want to open a trust account but will not keep people's money. And I don't know much about that. I think amnesty, yes.
Thanks, Xolisiwe. I mean, geez, looking at the time now, it is 11:28. We unfortunately have reached our time limit. It has been such an incredible and informative session, and I really thank you all, the speakers, the panelists today, for giving your insights and your views and being so candid and coherent in your inputs. And I think we can just see from some of the questions and the comments that have come through that people have really appreciated this session today. So I'm unfortunately, we have to wrap it up. Again, I'd like to give a final and huge thank you to the members of the NPPC, the organizations who I named previously, being SAIBIB, SAPOA, IASA, Rebosa, the NPF, NAMA, SABA, and SAYA, who have worked tirelessly over the last few months, making inputs to the proposed regulations that we had an opportunity to discuss today, and who have been working tirelessly in the background, engaging with the Department of Human Settlements, with the EAB, in various forums, to really try and ensure that the voice of industry is heard and taken into account as the new regulations are being drafted. And I thank everybody who has been a part of that process, not just the council, individual members themselves, but also everyone in industry who's been involved. I thank everyone who has made the time to attend the session today. We had over 450 registrations for this session today, and it's just really great and encouraging to see that industry is involved and really keeping an eye on the regulations and making inputs. As I said earlier, this is not the final opportunity to make your inputs. Clem has stated and shared with us that the cutoff date for the inputs is the 20th of November 2020, so that gives us plus minus another week and a half to make our inputs. So I encourage everybody who's on this call to make your inputs and submissions directly to your member organizations. So if you're a part of NAMA, if you're a part of Rebosa, you're a part of SAIBIB, please make your submissions directly to your organizations so that they can be included in your organization's written submissions, as well as in the NPPC's final consolidated submission. You know, we don't make change by ranting on Facebook. We make change by going through the proper channels and engaging with everybody, all the stakeholders who are involved in this process. And really, I thank you all for your constructive inputs to today's session. As stated previously, I'm Vuyiswa Ramokgopa. I thank you all for your time and look forward to hosting you in another one of these sessions in the near future.